Imagine getting a phone call telling you that you owe more than $20,000, not because of anything you did, but because someone took something from you without asking, and now they're gone, and the bill landed in your lap anyway. That is exactly what happened to one couple, and the legal nightmare they found themselves in is something that could happen to almost anyone who owns a vehicle. Stay with me, because this story is going to change the way you think about car ownership, insurance, and liability. Let's set the scene. A young couple, college students, both of them, living on tight budgets the way most college students do, had a project car. Now, if you're not familiar with the project car world, let me explain. A project car is a vehicle that someone is actively rebuilding, restoring, or modifying. It is not a daily driver. It is not road ready. It is a work in progress, sitting in a driveway or a garage with parts coming in and going out, systems being upgraded or replaced, and often with major components that simply do not function safely enough for public roads. This couple's car was exactly that. They were in the middle of brake work, active brake work. They even had text messages from just days before the incident where they were discussing what needed to be done to the braking system. The car was not insured because there was no reason to insure it. You do not insure a car that is not being driven. It was a project. It was supposed to stay put until it was finished and safe. The husband's brother had access to their lives in the way that family members sometimes do. And one day he made a decision that would ripple outward in ways that nobody could have anticipated. He took the car. No permission was asked. No permission was given. He just took it and drove it onto public roads in a vehicle that by any reasonable standard should not have been anywhere near traffic. The brakes were not finished, the car was not insured, and he had no right to be behind the wheel of it. What happened next was a tragedy in the most complete sense of the word. He crashed. The accident was serious enough that it involved another driver, destroyed that other driver's vehicle entirely. And the husband's brother did not survive. He passed away in the crash. In a single moment, a family lost a member, another driver lost their car, and this young couple found themselves standing at the center of a disaster they had no part in creating. Now here is where the story shifts from personal tragedy into a legal and financial nightmare. Because grief does not stop the insurance industry from doing its job. Weeks or months later, the other driver's insurance company came calling. Their message was simple and brutal. The car was registered in the husband's name, and because of that, they believed he was liable for the damages their client suffered. The number they put forward was over $20,000. For two broke college students, that might as well have been $20 million. They did not have it. They had no way to get it. And now a corporation with lawyers and resources was telling them they owed a debt they never agreed to. They had not pressed charges against the brother for taking the car without permission, and that decision made sense at the time. He was gone. What would pressing charges accomplish? You do not file a police report against someone who has already died in the accident you would have been reporting, so there was no formal theft documentation, no criminal record of the unauthorized use, just their word and their text messages against an insurance company's claim. They started calling lawyers. That search became its own kind of exhausting. Many attorneys told them they did not handle this type of case. Others were already representing the other side of the dispute. Finding someone willing to take their corner felt almost impossible, and every unanswered call or rejection letter added another layer of stress to an already overwhelming situation. So let's break down what is actually happening legally, because this is where things get complicated and where the lesson really lives. When a car is registered in your name, the law in most states creates what is called owner liability. The basic principle is that if you own a vehicle and someone drives it with your permission and causes an accident, you can be held responsible for the damages. This is why your insurance follows the car, not just the driver. It is also why lending your car to someone is not a casual decision. It is a legal act with real consequences. But the critical phrase in that principle is with your permission. Owner liability typically requires that the driver had either express permission, meaning you actually said yes, or implied permission, meaning you had a pattern of allowing them to use the vehicle. If neither of those things is true, the owner's liability is significantly reduced or eliminated entirely. What happened here was not permission. It was not even close to permission. Someone took a vehicle without asking, drove it in an unsafe condition, and caused an accident. That is closer to theft than it is to a loan. The text messages this couple had saved were genuinely significant. Documentation showing that the car was actively being repaired, that the brakes were not functional, that this was a known and ongoing project rather than a drivable vehicle. All of that works in their favor. It supports the argument that the car was not in a condition to be driven, that they had no reason to anticipate it being driven, and that any reasonable person would have known it was not road ready. That kind of evidence does not eliminate the legal battle, but it changes the shape of it considerably. The insurance company reaching out to them directly was also a tactic worth understanding. Insurance companies are businesses. Their job is to recover costs, and they will often make initial contact directly with individuals to see if they can resolve things quickly, sometimes before those individuals have had a chance to speak with an attorney. Receiving a letter or a call saying you owe $20,000 can feel final and official, like a court has already decided against you. It has not. That contact is the beginning of a negotiation or a dispute process, not the end of one. The worst thing you can do in that situation is assume the number they give you is settled fact. What this couple needed, and what anyone in a similar position needs, is an attorney who specializes in personal injury defense or auto liability. Not just any lawyer, specifically someone who defends against these kinds of claims. The challenge they faced in finding one is real and common, but those attorneys do exist, and many work on contingency or offer free initial consultations. Some state bar associations have referral services that can help match people with the right specialist. Legal aid organizations exist for people who genuinely cannot afford representation, and in cases involving significant dollar amounts, it is often worth the effort to find one, because the alternative, doing nothing or trying to handle it alone, usually ends much worse. If there is any formal documentation that can establish the unauthorized nature of the use, even after the fact, that matters too. Statements from people who knew the situation, any written communication that shows the brother never had standing permission to use the car, records showing the vehicle was unregistered for road use, insurance history showing it was never insured as a drivable vehicle, all of these pieces build a picture that contradicts the liability claim being made. Here is what every car owner watching this needs to take away. First, project cars need to be formally designated as non-operational where your state allows it. Many states let you declare a vehicle as non-operational, which changes its registration status and protects you from certain liability assumptions. Second, even if a car is not being driven, having some form of storage or non-owner liability coverage is worth looking into, depending on your situation. Third, if a family member or anyone else has access to a space where your vehicles are kept, boundaries about those vehicles need to be clear and ideally documented. A simple text message saying, "Don't use my car," can matter enormously in a legal dispute. And fourth, if you ever receive contact from an insurance company telling you that you owe money related to an accident, do not engage with them substantively until you have spoken to a lawyer. Even a free 30-minute consultation can prevent you from accidentally saying something that weakens your position. The couple at the center of this story was dealt a genuinely terrible hand. They were grieving. They were broke. They were being pursued for a debt tied to a tragedy they did not cause and could not have prevented. The system they were navigating is complicated and unforgiving, but there were paths forward, paths that required the right legal help and the right documentation strategy, both of which they appeared to have pieces of. If this happened to you, if you received a bill for an accident involving your car that you had nothing to do with, or if someone drove your vehicle without permission and caused damage, or if an insurance company is coming after you for something that does not feel like your fault, do not panic, and do not pay anything before you talk to an attorney. The number they give you is not the final word. Your situation has more options than it might seem in that first terrifying moment. Stories like this one are why understanding your insurance coverage and your legal exposure as a vehicle owner matters so much. Subscribe to this channel so you never get caught off guard by the kind of insurance reality most people only learn about the hard way.